case study series. Today we're looking at a situation that catches a lot of adult children by surprise. When a parent and a child own property as tenants in common, meaning 50-50 with no automatic survivorship, the parent dies without a will and an estranged spouse from decades ago suddenly has a legal claim on the house. This South Carolina property is under contract with a cash buyer, but the sale is on hold until probate is opened and title is cleared. The son reached out because time is critical. Okay, we're keeping every detail fully anonymized for privacy, but the facts are real, and they highlight why checking deed language and acting fast after death is so important. So, quick disclaimer, standard disclaimer, this is for educational purposes only. This is not legal advice. Every state is different. Always consult a licensed South Carolina probate attorney for your situations. Results will vary. All right, let's get into it. So, the case background, the son, we'll call him Terry, bought a house in Anderson County in South Carolina in 2008 and put it in both his name and his mother's name as tenants in common. That means 50% each, no rights of survivorship. His mother lived there full time for 18 years. She recently moved to be with Terry on hospice and unfortunately passed away on February 11th of this year, just 2 months after arriving. She did not have a will. If you recall, that's intestate. Terry already has a cash buyer ready to close, but the title company flagged the issue because the mother's 50% interest did not automatically pass to Terry. Her share now needs to go through probate in South Carolina, the state where the real estate is located. Further complicating everything, Terry's parents legally separated 25 years ago, but never divorced. The father is still alive, estranged, and has not been a part of the family for decades. So the core problem here, South Carolina intestate succession gives a surviving spouse a significant share of the estate, usually half, with the other half going to children if children are around. Even though the parents have been separated for 25 years, the lack of the divorce means the father may be entitled to a portion of the mother's 50% interest in the house. Here are the key issues Terry is facing. The deed does not have rights of survivorship, so probate is required for the mother's half. The primary probate could be held in New York, but since the real estate is in South Carolina, probate has to be opened down there, particularly because they're wanting to sell the property. And we've mentioned this before in South Carolina. If you're wanting to sell property owned by someone who's passed away and there is no will, you also need to get court permission to do that. Terry needs clear title to close the house quickly, doesn't want to lose the buyer. And the father would need to voluntarily sign a disclaimer or quitclaim deed to give up any claim. Otherwise, the estate must go through full probate. So without quick action, the sale is stalled and the family risks losing the buyer. So the client questions in our discussions, Terry had the exact same questions we hear from families in the same spot, and this happens more than you would think. Can my father still claim part of the house after 25 years of separation? Yes. Until there is a divorce or valid renunciation or disclaimer, the law treats him as the surviving spouse with intestate rights. Now, when they separated 25 years ago, there may be a separation agreement in there in which if you go with a lawyer and sign a separation agreement, typically they include language about spousal rights to intestate shares and things along those lines. But if you don't have one of those, then absolutely. If you're not divorced, then that surviving spouse has claim to the real estate. Do I really have to open probate in South Carolina? Yes. She is seeking to sell the property, and so she needs to get permission from the South Carolina courts in order to do that, which means she has to open probate. How long does this process usually take? From filing, the full probate process in South Carolina lasts a minimum of 8 months. Usually, it's going to take around 10 to 12 months if there are no problems. But often we can get court permission to sell the property quicker than that, usually between 4 and 6 months. The catch there is that when the property does sell, you have to keep the proceeds in a trust account until the creditor period is up. So here's the clear plan we came up with for our client. 1, verify the exact deed language and pull the full property records just to make sure we're not missing anything, and maybe there's rights of survivorship on there. Prepare a South Carolina disclaimer or quitclaim package for the father to sign, and that will have to be notarized and witnessed by him. And then file probate in Anderson, South Carolina to transfer the mother's 50% interest to our client. Once approved, petition the court for permission to sell the property, and then close with the cash buyer and complete the distribution of the property. We usually offer a flat fee for these types of cases as long as there's no argument or people aren't fighting for each other. And so if you can find an attorney that offers flat fees, I definitely recommend it. It keeps costs under control and you know exactly what you're getting. So the three big lessons from this South Carolina case study today. One, tenants in common does not automatically pass the deceased owner's share. Probate is required. This is important. When you're buying a house in South Carolina, and this is critical in South Carolina, and I'm sure many other jurisdictions as well, the magic words joint tenants' rights of survivorship has to be on the deed. If those words are not on the deed, it's treated as tenants in common, and you're going to end up in a situation exactly like this. A legal separation is not the same thing as divorce. An estranged spouse can still have inheritance rights. And cash buyers won't wait forever. The faster you open probate, clear title, the better chances you are of closing and cashing in on that deal. So pro tip, always check the exact wording on the deed when a co-owner passes. If it says tenants in common, actually you should do this before someone passes away, because after they pass away, it's too late. If you're on the deed with your spouse, and you're not in a state that recognizes tenancy by the entirety, someplace like North Carolina, it is imperative that you make sure the deed has joint tenants' right of survivorship on there. Any good real estate closing office in South Carolina will automatically put those on there for married clients, but sometimes that doesn't happen. So that's today's real anonymized probate case study. These joint ownership cases surprises come up constantly, but they are fixable. You just don't want to sit around and wait. If you co-own property with a parent, a spouse, or a loved one, or you're dealing with an out-of-state death in real estate, drop your biggest question in the chat here. I'll answer it live or follow up after the stream. So tomorrow, we'll be back with another probate or estate planning story, or maybe we'll dig into some Medicaid issues there. Final reminder, this is for educational purposes only. This is not legal advice. Always work with a licensed South Carolina probate attorney. Thanks for joining us. This has been Bobby Sawyer. I hope you have a great day, and we'll see you.